The boardroom smelled like expensive leather and bad decisions. Kenneth Walsh stood at the head of the conference table, my prototype in his hands like a trophy he'd already won. This tech is mine now. 5 words, delivered with the kind of certainty that only comes from men who've never been told no. His fingers traced the edge of the neural processing unit, the device that represented 3 years of my life condensed into 8 pounds of revolutionary technology. Kenneth, we need to discuss the licensing terms. There are no terms. He set the prototype down with deliberate care. Effective immediately, you're terminated. Security will escort you out. The technology was developed on company time with company resources, which makes it company property. The other executives around the table avoided my eyes. 7 people who'd sat through every development meeting, every breakthrough presentation, every late-night crisis when the project nearly collapsed. Now they studied their phones, their paperwork, the grain of the mahogany table, anything but the person being erased from the room. "You're making a mistake." My voice stayed level despite the adrenaline flooding my system. Kenneth's smile was the kind sharks probably envied. "The only mistake was letting you think you had any ownership of this project. You were an employee. Employees are replaceable." My phone was already in my hand, already unlocked to the secure app I'd hoped I'd never need to use. 3 taps, 1 confirmation, the geographic lock activated with a silent ping that no one else in the room could see or hear. "All right." The word came out calm, almost pleasant, "if that's your decision." He wasn't expecting agreement. His expression flickered, confusion, then suspicion, then dismissal. "Security is waiting outside." "One thing before I go." My thumb hovered over one final button. "As the global patent holder for the core neural processing architecture in that prototype, I should inform you that your entire production line just became illegal." Kenneth's laugh was sharp. "Nice try. Company IP policy clearly states..." The screens along the boardroom wall flickered to life, displaying the patent documentation I'd filed 18 months ago in Geneva. Not for the complete prototype, for the fundamental neural processing architecture that made everything else possible. International Patent WO2321084721. Inventor and sole rights holder, Ilara Novak.
Before we get into what happened next, if you're enjoying this story about protecting your work and standing up to corporate theft, consider subscribing. We just hit our first milestone and we're pushing toward 2,000 subscribers. Your support keeps these stories coming. Now, let me tell you how we got here. My name is Ilara Novak, and up until 17 minutes ago, I was the Chief Technology Officer of Neural Edge Industries. My official title was impressive, but the truth was simpler. I was the person who'd invented the technology that Kenneth Walsh had just tried to steal. My dad was a machinist, 40 years working in manufacturing plants across the Midwest, coming home with oil under his fingernails and pride in his craftsmanship. My mom taught elementary school in districts that couldn't afford basic supplies, buying markers and paper with her own money because she couldn't watch kids go without. They taught me that creating something meaningful mattered more than profiting from it, but they also taught me something equally important. Never let someone take credit for work you did with your own hands. That wasn't about money or status, it was about understanding that every person's contribution has value, that empathy means recognizing effort, and that humility doesn't mean letting others steal what you've built. I graduated MIT with a doctorate in computational neuroscience, held 4 patents in machine learning architecture before Kenneth Walsh approached me with an offer that seemed too good to refuse. For 3 years, we built, and somewhere in those endless nights of coding and testing, we created something revolutionary, a neural processing unit that could interface with existing AI systems and boost their efficiency by 340%. $750 million. That's what the technology was worth according to Goldman Sachs, conservative estimate. Kenneth had seen those numbers. Apparently, he'd also seen an opportunity.
6 months before that boardroom confrontation, the warning signs started appearing. Kenneth attending more development meetings, asking detailed questions about the architecture. His VP of Legal requesting copies of all project documentation. Casual comments about ensuring the company's IP was properly protected. I should have seen it coming. Maybe part of me did. 3 months ago, I filed the international patent, not for the complete system that genuinely was collaborative work, but for the core processing architecture, the fundamental innovation that made everything else possible. That piece was mine, developed before I'd ever joined Neural Edge, refined during personal time on personal equipment. The patent application was strategic, filed through the World Intellectual Property Organization, establishing priority in 153 countries simultaneously. Then I added a geographic lock feature to the prototype's operating system, a kill switch that could restrict the technology's functionality based on patent law. Insurance, I told myself, just in case. Kenneth made his move this morning. The meeting invitation appeared at 7 a.m. Strategic realignment discussion, mandatory attendance. No agenda, no context. 7 executives were already seated when I walked in. The prototype sat in the center of the table like evidence at a trial. "Ilara, thank you for joining us." Kenneth's voice had that false warmth that preceded bad news. "We've been reviewing the neural processing project, and we have concerns about development pace and resource allocation." "The project is on schedule," my response was measured. "We're 3 weeks from beta testing." "That timeline is no longer viable." Christine Morrison, his VP of Legal, slid a folder across the table. "We've decided to restructure the development team under new leadership." The folder contained termination papers, effective immediately, severance calculated to the minimum legal requirement, a non-compete clause that would have prevented me from working in the field for 3 years. "This is theft." The words came out quiet but clear. "You're firing me to avoid the equity payout when the technology launches." That's when he picked up the prototype, when he said those 5 words that triggered everything that followed. The security guards were professional about the escort. My office was on the 4th floor. 3 years of work condensed into one box of personal items: laptop, external drive, the photo of my parents at my MIT graduation. My phone buzzed continuously as I packed, text messages from team members who'd already heard. "Derek, what the hell is happening? They're saying you're fired." "Samantha, this is insane. The project was your vision." "Oliver, legal is telling us not to communicate with you. I'm using my personal phone. What do you need?" I typed back, "Don't risk your jobs. I've got this handled. Trust me." The parking garage was dim and quiet. I sat in my car without starting the engine, staring at the secure app on my phone, the geographic lock confirmation still glowing, the patent documentation, the leverage Kenneth didn't know I had. I called my dad. "Ilara? Hang on, let me step outside." Machinery noise faded. "What's wrong?" "I got fired today. They're trying to take the technology. Kenneth claims everything belongs to the company." Silence. Then, "Did you protect yourself?" "I have the international patent for the core architecture, and I activated a geographic lock. Their production line is illegal now in 153 countries." A low whistle. "Ilara, that's nuclear." "Dad, he stood there and told me the technology was his. 3 years of my life, and he just claimed it." "You're not nothing." His voice carried absolute certainty. "You built something revolutionary. Don't let some corporate thief make you forget that." After the call, I contacted Jennifer Wu, a patent attorney my mother recommended, former IBM counsel, known for winning impossible cases. "I read your paper on adaptive architecture last year," Jennifer said when I explained the situation. "Brilliant work. Can you be at my office in 40 minutes?" Jennifer Wu's office was everything you'd expect from a top-tier patent attorney. Books on intellectual property law, framed patents on the walls, photos with tech founders and innovators. She was mid-40s, sharply dressed with focused intensity that commanded attention. "Show me everything." I walked her through it. The original architecture designs from before joining Neural Edge, the patent application and approval, the employment contract, the termination papers, the technical specifications showing how the core architecture enabled everything. Jennifer took notes, asking questions that cut straight to potential complications. The geographic lock. Explain how that works. The prototype's operating system checks its location via GPS. It cross-references that with my patent database. If it's in a jurisdiction where I hold patent priority, the system requires licensing verification. Without valid licensing, core functions are restricted. Restricted or disabled? Restricted. Basic functions work, but the efficiency gains, the thing that makes it valuable, are locked. It becomes a very expensive paperweight. Jennifer's smile was sharp. "That's elegant. Neural Edge will argue sabotage, but you're preventing patent infringement, which is your legal right." She explained the battle ahead. "Kenneth has resources, legal teams, connections. This will get ugly. He'll paint you as a disgruntled employee holding the company hostage." "Let him. He tried to steal my work." Jennifer studied me, then nodded. "If we're doing this, we're doing it comprehensively. Hourly rate plus expenses. Won't be cheap. 100,000 minimum, possibly double if this goes to trial." I thought about my savings, the equity Kenneth had stolen. Do it. We spent 3 hours building the case. Jennifer recorded my statement, documented the timeline, prepared the filings. "Why didn't you disclose the patent to Neural Edge when it was approved?" "Because Kenneth has a reputation, 3 previous CTOs who left under unclear circumstances, all without equity despite promises. The patent was insurance. Smart insurance." Jennifer closed her laptop. "Here's what happens next. I file declaratory judgment tomorrow. Send cease and desist to Neural Edge. They'll respond aggressively. This escalates." The cease and desist hit Neural Edge at 9 a.m. By 11 a.m., Kenneth had called an emergency press conference. I watched the live stream from my apartment as Kenneth stood before cameras, his expression perfectly calibrated to convey wounded integrity. "Yesterday, we terminated an employee due to performance concerns. Today, that individual is attempting to extort this company by sabotaging technology developed under our employment." His voice carried conviction. "Neural Edge will vigorously defend our rights against this baseless claim." A reporter shouted, "Mr. Walsh, can you confirm the technology is currently non-functional?" Kenneth's jaw tightened. "We're experiencing minor technical issues. Production timeline remains unchanged." Lies. The geographic lock wasn't minor and their team couldn't resolve it without the core architecture. Jennifer texted, "He's panicking. Good. Don't respond to press." Derek, my former team lead, messaged, "Factory shutdown confirmed. Everything dead. Kenneth losing his mind. They're offering bonuses if we can crack your lock." "Don't. You'll be violating patent law." Already told the team, "Your work, your rights." The next 48 hours blurred into legal documentation and strategy sessions. Kenneth hired Whittemore and Associates, one of Boston's most aggressive firms. Their first move was filing an emergency injunction to force me to remove the geographic lock. Jennifer had anticipated it. Our counterfiling included documentation of Kenneth's statement, "This tech is mine now," recorded by the boardroom's own transcription software. Evidence of wrongful termination. Timeline showing the patent predated any employment contract. The emergency hearing was Thursday. Judge Martha Brennan presided. A woman in her 60s with a reputation for no-nonsense efficiency and zero patience for corporate games. Kenneth's lawyer, Thomas Whitmore, was silver-haired confidence in an expensive suit. "Your Honor, this is straightforward employee sabotage. Miss Novak was terminated for legitimate reasons. In retaliation, she activated a kill switch on company property. We seek immediate injunctive relief." Judge Brennan turned to Jennifer. Miss Wu. Your Honor, this is patent protection, not sabotage. Miss Novak holds an international patent for the core architecture. Neural Edge attempted to claim ownership by terminating Miss Novak and declaring the technology company property. The geographic lock prevents patent infringement, which is Miss Novak's legal right. Whitmore jumped in. The employment contract clearly states all work product belongs to Neural Edge. Jennifer slid documents to the judge. The patent application includes dated documentation showing the core architecture was developed before Miss Novak's employment. The contract can't retroactively claim rights to pre-existing intellectual property. Judge Brennan read carefully. The courtroom was silent except for rustling papers. Finally, she looked up. Mr. Whitmore, does your client dispute the patent filing date? Whitmore hesitated. No, Your Honor, but... Then Miss Novak has valid patent rights. Judge Brennan's tone sharpened. You're asking me to force the patent holder to enable infringement of their own intellectual property. That's not how patent law works. Your Honor, Neural Edge has invested millions. Miss Novak's actions are causing irreparable harm. Did your client attempt to negotiate a licensing agreement before this dispute? Silence. Did your client acknowledge Miss Novak's patent rights and seek terms for using the protected architecture? More silence. Judge Brennan closed the folder. Motion for emergency injunction is denied. If Neural Edge wishes to use technology incorporating Miss Novak's patented architecture, they can negotiate a licensing agreement. This court will not compel patent infringement. The gavel came down. Kenneth's face went through several shades of red. Whitmore requested an expedited hearing on the underlying employment dispute. File your motions, Judge Brennan said, but the injunction is denied. Ms. Wu, I assume your client is willing to negotiate licensing in good faith. Jennifer stood. Absolutely, Your Honor. However, any arrangement must address the wrongful termination and attempted IP theft. That's for settlement discussions. I'm ordering mediation. First session within 2 weeks. Outside, Jennifer's smile was pure satisfaction. That went better than expected. She basically told them to settle. She told them they can't force you to enable patent infringement. Kenneth has 2 choices: negotiate with you or abandon $750 million in technology. What do I want out of this? That's the question. I thought it through. Patent rights confirmed, proper licensing terms with ongoing royalties, equity stake restored and paid out. Jennifer made notes. Be prepared for this to get nasty. Kenneth will try to discredit you. The smear campaign started that afternoon. Anonymous sources in tech blogs claiming I'd been difficult, missed deadlines, shown concerning behavior. TechCrunch. Sources suggest terminated CTO had pattern of erratic behavior. Industry Insider. Questions raised about Ilara Novak's contributions. I ignored all of it. Jennifer had been clear. No public statements, no interviews. Let the legal case speak for itself. But Derek texted, everyone on the development team knows the truth. We're documenting statements about who actually led this project. Oliver, HR is pressuring us to sign statements saying you were problematic. Nobody's signing. Samantha, they offered me your old job. I told them to shove it. These people were risking their careers for principal. The court-appointed mediator was retired Judge Leonard Kozlov, known for cracking impossible cases through strategic application of reality. First mediation session was the following Tuesday. Both legal teams, both principals, 6 hours to see if settlement was possible. We sat in separate rooms while Kozlov shuttled between us, carrying offers and counteroffers. His first visit. Neural Edge is offering $2 million for full patent assignment and release of all claims. Jennifer didn't look up. No. That's your entire response? Judge Kozlov, the technology is valued at $750 million. My client holds the core patent. $2 million is insulting. What's your counter? Patent rights remain with Miss Novak. Neural Edge receives exclusive license for 10 years with 8% annual royalties on gross revenue. Miss Novak's equity stake restored and paid out at current valuation. Additional $5 million for wrongful termination. Kozlov wrote it down. They're going to say that's unreasonable. Then they can explain to shareholders why they're abandoning $750 million because they tried to steal it and failed. The back and forth continued for hours, each offer slightly better but never approaching reasonable. Kenneth was playing war of attrition. The final offer, $15 million for patent assignment, 4% royalties for 7 years, half the equity restored. He's moving, Jennifer noted, but not enough. Tell him no. Kozlov returned looking tired. Miss Novak, Mr. Walsh asked me to remind you that litigation is expensive and uncertain. He can outspend you 10 to 1. Judge Kozlov, please tell Mr. Walsh that I grew up watching my dad work with his hands for 40 years, and my mom spent her own money on school supplies for kids who had nothing. I understand the value of work. I understand fairness, and I understand that some things matter more than money. He won't like that answer. I don't need him to like it. The mediation ended without settlement. Second session scheduled for 3 weeks out. Outside, Jennifer was quiet until we reached her car. You did good. Kenneth's used to people folding. You didn't. What's my walkaway point? $20 million for patent assignment, or keep the patent and license exclusively at 6% royalties for the life of products using the architecture. Full equity stake restored and paid out. $10 million for wrongful termination and reputation damage. Jennifer whistled. That's aggressive. That's fair. The technology is worth $750 million. I'm asking for less than 5%. Kenneth would pay his investment bankers more. He'll never agree. Then we go to trial, and I win because the patent is clear, the theft is documented, and his own boardroom recorded him claiming my invention. The second mediation 3 weeks later opened with different energy. Kenneth looked like he hadn't been sleeping. Kozlov's first visit carried a real offer. Patent assignment for $25 million, equity stake fully restored, paid at current valuation plus 20% premium, $5 million for termination settlement, NDA covering all parties. Jennifer's eyes met mine. This was Kenneth blinking first. What about reputation damage, the smear campaign? Kozlov nodded. Joint statement clarifying termination was mutual, recognizing your contributions, wishing you well. Not good enough. Kenneth called this sabotage and extortion. I want public statement acknowledging the patent rights were valid and the dispute arose from good faith disagreement about IP ownership. After negotiation, they agreed to the statement with language modifications. One more thing, I said. I want the option to buy back the patent after 5 years at a predetermined price. If Neural Edge hasn't brought a product to market or abandons the technology, ownership reverts to me. Kozlov raised eyebrows. That's unusual. The technology matters to me beyond money. I don't want it shelved. If they're actually going to use it, fine, but if not, it comes back to me. After long deliberation, Kozlov returned. They'll agree to reversion if technology is abandoned or no product reaches market within 3 years. Buyback price $20 million. Deal.
Settlement paperwork arrived Wednesday. 37 pages of legal language. I read every word twice before signing. The signature meeting was brief. Kenneth and I sat across a table one last time, lawyers flanking us. He signed first, all sharp angles and pressed ink. I signed second, cursive flowing across the line. Thomas Whitmore collected documents. This settlement is binding. Funds transfer within 3 business days. Kenneth stood without speaking. At the doorway, he paused. You could have had a real future at NeuroLedge if you'd just been reasonable. The audacity was almost impressive. Kenneth, you tried to steal my work. I protected it. The only person who wasn't reasonable was you. His jaw tightened, but he didn't respond, just walked out. The fund transfer hit Friday, $30 million. Equity payout Tuesday, $18 million more. $48 million total. It didn't feel like winning, it felt like compensation for something stolen and partially returned. 3 months after settlement, I incorporated Novak Neural Systems. Not competing with NeuroLedge, I'd licensed them exclusively, but other applications existed: medical uses, educational tools, accessibility technology. Everything Kenneth had dismissed as not profitable enough became our mission. I hired Derek as head of development, Samantha joined as VP of operations, Oliver as lead architect. The team that built the original prototype now free to create something new. Funding came from venture capital firms who'd watched the settlement and recognized what it meant. We closed Series A, $80 million. A year later, NeuroLedge brought their product to market. Strong reviews. Sales exceeded projections. My royalty check from that first year was $12 million. Kenneth had called my patent protection sabotage. Turned out it was just good business. 2 years after the settlement, I got an email from Christine Morrison, Kenneth's former VP of legal. I hope this finds you well. I've recently left NeuroLedge and wanted to reach out. I was part of the legal team that tried to claim ownership of your patent, and I've regretted my role ever since. Watching you fight taught me something about integrity and IP law that I'd lost in corporate practice. I'm now working with a nonprofit helping independent inventors protect their work. Your case has become a teaching example in patent law courses. Thank you for not backing down. Christine. I responded offering to help with expert testimony and case studies for protecting independent inventors. That partnership led to a pro bono program. Novak Neural Systems began offering patent support to independent inventors who couldn't afford traditional legal protection. Jennifer Wu joined as consultant. The program helped 47 inventors in its first year, small interventions preventing people from losing their life's work. Kenneth's story took a different path. NeuroLedge's board forced him out 18 months later, claiming he'd mismanaged company IP and exposed them to unnecessary legal risk. He landed at another company within months because men like Kenneth always do, but his reputation had changed. The industry knew what he'd tried to do, knew he'd lost. Talented people stopped answering his recruiting calls. I ran into him once, 3 years post-settlement, at a conference in San Francisco. We were both speaking, him on scaling tech companies, me on protecting inventor rights. Alara. He stopped me in the hallway. I saw your talk. It was good. Thank you. Awkward silence filled with everything unsaid about the boardroom, the prototype, the battle. I should have handled things differently, he said. The termination, the IP situation. Not quite an apology, more acknowledgement. You should have, but you didn't, and here we are. Your company is doing well, the medical applications, impressive work. It's work that matters, that's what I care about. He nodded with something almost like respect. For what it's worth, I've learned from what happened between us. Good, make sure you keep learning. I walked away before he could respond. 5 years after Kenneth claimed my technology as his own, I stood in the patent office in Geneva, accepting an award for innovation in neural processing architecture. My parents were in the audience. Dad, retired now, still had those machinist's hands. Mom, still teaching part-time because she couldn't imagine stopping, beamed with pride. Derek, Samantha, Oliver sat front row. They'd built their own success, but flew across the world to be here. Jennifer Wu was there too, having become not just my attorney, but a genuine friend. The speech I gave was brief. This award recognizes a patent I had to fight to protect. It represents not just innovation, but the principle that people who create something deserve to own it. Too many brilliant minds lose their work to corporate structures that value profit over people. If this accomplishes anything, I hope it encourages other innovators to protect their work, know their rights, and stand up to anyone who tries to claim credit for what they built. Thank you. The evening ended with dinner overlooking Lake Geneva. No fancy speeches, just good food and better company. "What's next?" Derek asked. "You've conquered the patent world, built a successful company, changed an industry. What's the next mountain?" "More of the same. Better applications, better protections, better systems that make it harder for people like Kenneth to steal from people like us. That's going to take a while. Good thing I'm not going anywhere." My phone buzzed. Royalty payment from Neural Edge for Q4, $8.3 million. 5 years of payments showing no signs of slowing down. Kenneth had tried to take everything. Instead, he'd given me a foundation to build something bigger than either of us had imagined. The geographic lock I'd triggered had become symbolic. Boundaries matter. Rights matter. Protecting your work isn't sabotage, it's survival. And sometimes, when you stand your ground against someone who thinks they can take what's yours, you don't just survive. You build something that lasts. If this story meant something to you, if you've ever had to fight to protect your work, or if you believe innovation should be respected and compensated fairly, subscribe to this channel. We're building toward 2,000 subscribers, creating a community that values creators over corporations, substance over theft. Your subscription helps us keep telling these stories. Thank you for being here.